Okay, good morning and good afternoon, everyone. My name is Jayman Chavda. I'm an attorney with Chug LLP in the Atlanta, Georgia office. Welcome to our webinar series where we discuss trending topics in our various fields. So for those who are not familiar, Chug LLP is a full-service law and CPA firm. We have 7 offices in the United States, 7 in India, and then we have our global affiliate network. So we provide outside general counsel services in 4 main practice areas of corporate law, tax and accounting, litigation, and immigration. So for today, in response to the pandemic, the government enacted the CARES Act and provided a stimulus package to certain businesses. While that helped the vast majority of businesses this year, many others have struggled and hope for a second rescue package, which is unlikely to come before January at the earliest. And so for those that have gone through some financial difficulty, today's topic will provide an overview of bankruptcies and restructuring with a specific focus on Chapter 11 and Subchapter 5 of the Chapter 11 Code. So we've got a great team presenting today. I'm happy to introduce Esther Q from our Reston office, Dilawar Fazal from our New York office, Shagun Parekh from Santa Clara, and Min Luong from our Los Angeles office.
Hi, everyone. Thank you all for being here today. Thank you, Jayman. Jayman, could you please start by providing an overview of bankruptcy? What parties are involved? What happens to the debt? The stages of bankruptcy?
Absolutely. Thank you, Min. So to understand and to get to the crux of today's topic, we have to kind of understand what bankruptcy is. So it's a legal proceeding in which a judge and court trustee examine, excuse me, the assets and liabilities of individuals and businesses who can't pay their bills and decide whether to discharge those debts so they're no longer legally required to pay them. So when the petition is filed, it creates an estate, and so the parties to the estate are the debtor, so that's the person or entity that files for bankruptcy protection, and that can only be a U.S. resident or municipality or entity that is defined under the code. The trustee is generally assigned to Chapter 7 and 13 cases, sometimes other chapters as well, and their job is to evaluate and sell to gather the funds and to pay creditors. So it's generally a practicing attorney or CPA, but they don't necessarily have to be. So the creditor is the individual or entity to whom the debtor owes money. And one of the more important aspects of the bankruptcy code is the automatic stay. And so that's an injunction that automatically stops all lawsuits, foreclosures, garnishments, and any collection activities against the debtors as soon as the bankruptcy petition is filed. And then there are certain exemptions and exceptions that get into it, such as the debtor's primary residence, tools of the trade, that type of thing. And then finally, there's the discharge, which essentially releases the debtor from any personal liability and kind of wipes those debts clean. And one final point on that, Min, is that if there is a business bankruptcy, an attorney must be used.
Thank you for the overview. Now let's get more into detail, Jayman. Could you tell us more about Chapter 7, the type of businesses that would explore this option, and Chapter 13? Can you touch briefly on that?
Yeah, absolutely. And like I said, to touch briefly on just that and to understand the crux of today's topic, which is Chapter 11, we have to look at briefly Chapter 7 and sometimes 13 as well. Chapter 7 is a straight liquidation case, and so that means that you're going out of business or you have no assets, you don't expect any money coming in, and none of those exceptions or exemptions will apply really to save your individual liability. And corporations don't really have exemptions under a Chapter 7, and so that's the more dire option. And there's a means test, and so if there's any of the attendees out there that want to discuss more on the Chapter 7, let us know, but that's not really today's focus topic. And the Chapter 13 is an individual-only reorganization or repayment plan. So it allows the debtor to keep assets, but commit the future income to creditors. So it's usually about 3 to 5 years of a repayment plan, and there's a regular income that's required. So, and there's certain debt limits that are on the page there as well. So since we've touched on the Chapter 11, Esther from our Reston, Virginia office, if you could please tell us a little bit more about Chapter 11 bankruptcies.
Sure, thank you, Jamin. Yes, a case filed under Chapter 11 of the United States Bankruptcy Code is frequently referred to as a reorganization bankruptcy. So basically, it is for the business that they want to keep the operation, but still need time to reorganize and to start with the new strategy to make their business flourish. So in that case, they probably will choose Chapter 11. So, but who is qualified to file under Chapter 11? Actually, both individual and the entities can file under Chapter 11. So, but compared to the other chapter, why the individual would file under Chapter 11? Basically, it's a viable option if they don't want to liquidate all their assets like in Chapter 7, or they have too much debts, so they're not qualified under Chapter 13. So in that case, they're gonna file under Chapter 11, specifically for the celebrities and the people who has a lot of debts, but also has some assets for it. So, but however, Chapter 11 is a little bit expensive and also complex because it has different character, which is very important. The first is, as we all said, the Chapter 11 is about reorganization bankruptcy. So which means that it gave the opportunity to the company to restart their business as a new entity. So in that case, they still has to come up with a plan and to pay off the debts and make up a plan to make their business grow up. So in that case, definitely there's some plan and specific detail in the plan. So in that case, all the things will be customized, especially it involves different parties and parties can object to that plan. So in that case, it can be a longer time. And also, in generally, it also involved the mandatory appointment of trustee. So almost from every aspect, the case is monitored and then need to get approval from the court. So in that case, it also can be very expensive. Another character, which is a pro and benefits under Chapter 11, is allow the company to still stay in business. So in that case, the company has the opportunity to solicit the new contract and to try to change the strategy and to maintain the business. So in that case, definitely, as I said, there are a lot of different parties going to be involved, such as unsecured creditors and creditors, and also trustee, the banks. So in that case, all different parties has a say on this Chapter 11 bankruptcy code, and if they are objected to the specific acts, they can file some motion to the court and to object the specific acts. So, and last point is plan. So in that case, before the Chapter 11 filed, definitely the company is recommended to think about and consider their plan in the future. So in advance to avoid some confusion and objections in the future. Thanks, Jim. Give it back to you.
Thank you, Esther. That's a good point that you made about how one of the major benefits is that the businesses can retain control and operate the business still during the bankruptcy. So can you tell us how businesses can use Chapter 11 to their financial advantage?
Sure. So like I said, because Chapter 11 allows the entity to continue operating the business, although it's closely monitored by the court and also definitely was subject to the objections to all different parties. But the best interest for them is they can still run the business even after filing the Chapter 11. So once in bankruptcy, high inventory of dormant or slow-moving items can be used to generate cash, which is very important for the corporation by being sold at a below normal price. And also for the AR, it can be collateralized. A new customer with long-term needs can be solicited because it's definitely a better financial outlook. So in that case, I would like to introduce a new concept, which is not a new concept. It's a critical vendors. So the critical vendors are the business partner who really help the growth of the business. So in that case, the new customers with long-term needs can be solicited. New supplier also can be approached because of more certain financial backings. And another really good thing under Chapter 11 is the company can choose whether to terminate or continue an executive contract, such as the lease. So they have the opportunity to terminate the bad lease and terminate contracts and covenant, which may be selectively terminated. So basically, what I mean is this contract can be considered as executed contract. So in that case, the obligation and the rights of both parties are still ongoing during the bankruptcy procedure. So in that case, the company can decide whether they want to continue go ahead with the party or not. So and also of course because it's bankruptcy, so losing operation can be ended, and lawsuit and the judgment can be thrown into the pile because it's definitely is frozen. It gives the all great opportunity for the company to really consider about the current status and to decide which way is the best. Thank you, Jamin.
Thank you, Esther. Agreed that one of the largest expenses are probably the leases that the debtors potentially have, and being able to assume or reject the lease can be a great asset. So, so you mentioned that the Chapter 11 has a plan of reorganization, and that's essentially how the debtor will repay the creditors. Can you tell us more about the reorg plans?
Sure. Yes. So definitely the reorg plan is one of the most important part under Chapter 11 because it's totally, deciding the strategy and the future of the company, the way it's gonna go. So the filer must fully disclose the background information so that a creditor can be make a full informed decision about the feasibility of the proposed plan. And of course, if they agree, they have the right to vote. If they think it's not the best interest of the creditor and not the best interest for the company to grow, definitely they can object that. So another thing is making an informed decision. Other than in making the informed decision, generally the debtor has exclusive rights to propose a reorganization plan for the first 4 months. So however, the court of course can extend the debtor's exclusivity period for up to 18 months. So after the petition date, once the exclusivity period expires, the creditor committee or other parties can propose alternate reorganization plan, and the creditor are entitled to vote on whether they accept this plan or not. Of course, the plan is very important. It's also in that it will fix the systematic issues that led to the bankruptcy. So in the plan, they're gonna explain, which creditor are paid and how much and over what time, they will be paid, and also fix the issues which caused the bankruptcy. It gives the company a tremendous time to think about the better way to work it out. And also in the plan, it should develop a communication plan for the stakeholders, like creditor and the stakeholders, shareholders, sorry. So it's very important to specify it in the plan. So as I said, the creditor can vote on the plan, and of course the plan is one of the most important part that they will consider. So I hope it clearly explain a little bit. Thank you, Jamin. Give it back to you.
Yeah, thank you, Esther. So can you talk to us a little bit about, so once the plan is there, the next step is to get it confirmed. So can you talk about how the plan gets confirmed, and how does the creditor come into play there?
Sure. Under Chapter 11, as I repeatedly said, the people, the filer can still play the role, which is very important for the operation of business. So the filer continue to run the everyday function of the business, and they consider it as debtor in position. So they have the obligation to run the business properly and to play fair to all the creditors, and also supervised by the bankruptcy court. It's also very important because since they have the role to decide which is the best way for the company, but however, in some scenarios, they still need to get approval from the court because some decision can be considered as out of normal business activities. So for example, to pay attention, so the court must approve any assets the debtor wants sell in the ordinary business, a course of business such as like a real property. So let us say if the filer has a commercial property, they cannot sell it directly out without the approval from the court because definitely it touched the interest of the stakeholders. And then the second one is they cannot enter into a lease or breaking a lease without approval of the court, and also enter the mortgage or secure the financing arrangement that allow the debtor to borrow money. I think that's pretty clearly and easy to understand because they will already owed money to a lot of parties, so they cannot incur all additional debts without approval. And also for the strategy, they cannot shutting down or expanding the business operation without approval or enter into or modifying the vendor licensing and other contract agreements. So basically, as we said, the Chapter 11 helps the company to do a lot of operation and business and give them plenty of opportunities, but still they are supervised by the court. And of course, if the act is objected, then they will receive the objection. All right, thank you so much, Jamin. I think I need to give it back to you.
Sure, thank you, Esther. That was very helpful. So we'll move over to Santa Clara. Shagun, can you please talk to us about the benefits for businesses that want to file for Chapter 11?
Sure, Jamin. So one of the first ones, like you rightly touched upon in the start, is the automatic stay. So what happens here is once you file, the court automatically issues like a stay or an injunction against any and all creditors and other parties who are trying to collect from you. So they are temporarily prevented from taking collection actions. This means that no more calls or letters from debt collectors, lawsuits on debts, foreclosures, etc. But obviously, this does not cancel your debt. It's like it only suspends your debt collection proceeding until the bankruptcy case is complete or the stay is lifted. So it kind of gives you some breathing room until you figure out a plan, which is kind of really important when you're in this situation. And another benefit of filing under Chapter 11 especially is that you get to continue your normal business operations while you formulate your bankruptcy plan. So it's not like you have to come to a halt and stop all operations. Like if we look at American Airlines, when they filed for bankruptcy, they kept their planes in the air. They didn't have to stop. And this is a highlight benefit because even if your business has been through some rocky times, like filing may actually give you this much needed direction to reassess what's happening and get back on track while your operations are still on. So that's definitely a good benefit from this. There's also a slightly ironic benefit here where some lenders are actually more willing to lend you money during bankruptcy because then they would have been if you hadn't filed, because this is the kind of funding that we call the debtor in possession financing. And usually it's available when the creditors or the lenders can see the credibility of the company and they see that there's a viable plan to get back on track. So it's not down the drain, So, and this is a big benefit for the debtor because it allows them to, you want to reorganize, you want to plan, but this allows you to also have some cash on hand, which is very essential to get things going and get your plan going. So that's a big benefit that I would want to highlight there. And additionally, under the bankruptcy code, as a debtor, you can also, in certain situations, reject contracts and leases when you file for bankruptcy. So what this allows you to do is, again, create some more breathing room for you temporarily, where although your lessors will get a claim on your bankruptcy, but that's at a later stage. In this current very crucial stage, you get a little breathing room with this process.
That's great. Thank you, Shagun. So let's say I'm a debtor and I have a loan, but I owe more than what the collateral is worth. What happens then?
So in that case, Jamin, there would be what we call like a strip down of business secured loans. That's also like a benefit of filing. So if you owe more than what your collateral is worth, in that scenario, it's possible that you can strip down the unsecured portion of the loan. So what this, so it essentially helps you get out of paying your negative equity, which is your unsecured portion. So say you have a debt for like say 300K, but you have 200K of collateral on it, your 100K could possibly get eliminated, like stripped down. That's in that scenario, that's what would happen. Additionally, in bankruptcy scenarios, when you file, you are also getting the benefit that you can sell your assets free and clear. So obviously you want to increase your inflow of cash, you want to sell your assets, but if you have like a security interest or a lien on what you have, then if you file for bankruptcy, the court allows you to sell these assets free and clear of such interest to a good faith buyer. So that's definitely a big benefit and is a helpful thing because it lets you create your cash flow without worrying about what's going to happen. And if we look at the taxation bit of it, there are debtors who have tax debt from recent years. So when you file for bankruptcy, what happens is you don't immediately have to pay it right away. You get, again, some time for you to like plan it out, include it in your plan for Chapter 11. So it's there and it's going to be across a time period, but it's not immediate. So this gives you a little breathing room again where you can plan it out and then pay it off. So that's something that's helpful as well. And another thing I would like to touch upon here is when you're in this situation as a debtor, you may be owing money to more entities or more people than one. And you're obviously trying to juggle a lot of things at this point. So when you file for bankruptcy, what this does is consolidates all your claims and brings them to the bankruptcy court. So it's what we call the collective remedy. So all the claims that are against you will come under this. And it's so efficient here because, and it's more valuable and efficient as it saves you time, money, and energy. And you kind of need all three to capitalize on all three at this time. So it's really helpful to have it in one place rather than going to different places, defending yourself or getting things sorted at different entities. So, and also lastly, in many instances, like you mentioned, the discharge portion, where you can get a discharge of your pre-bankruptcy unsecured debt. So it's possible but this is possible when you properly file a Chapter 11 plan, and you're then able to simply eliminate some portions of it according to the way you're going to pay it out. So there is a chance that a portion of your unsecured debt will just get eliminated or discharged in this way. But the important thing to note here is that this is applicable when you're filing a Chapter 11, but not when a corporation is simply liquidating under Chapter 7.
Got it. Thank you, Shagun. So as exciting as bankruptcy is, the government enacted the Small Business Debt Reorganization Act of 2019, which is also known as Subchapter 5 of Chapter 11 bankruptcy. So can you please tell us about that, Shagun?
Sure. So this actually was enacted last year in August, and it had an effective date of February 19. So it went into effect by February 19, and it basically comes at a really good time because this is meant, the purpose of this thing, this subchapter is to make Chapter 11 more viable for small businesses. And it strikes a good balance between 7 and 11. So it's more streamlined and they've purposefully made it that way so that it lowers your cost of filing for bankruptcy. It makes it more streamlined in the sense that the procedure is easier to follow. There are a plethora of benefits which we will be talking about as we proceed. But what happens here is that small businesses get the benefit of Chapter 11 and also are able to handle their business. And so when this originally came in, it came in with the threshold of 2.7 million of total debt. So if you had up to that much, you could file under this. But through the CARES Act, due to COVID-19, The CARES Act has now been in place and has increased this to 7.5 million, which is a big increase, and this is in place through March 2021. So until then, at least we know that any debtors having a debt of under 7.5 million could file and make use of this.
Great. Just to kind of reiterate that's in place until March 2021, and so if anyone has that, then that's they should file prior to that, right?
Right. So as of now, we know that it's we know for sure that it's in effect till March 2021. So this would be the right time if you're considering it. This would be the right time to do it, because you don't know if they're going to extend it, and we don't know if that's likely right now. So rather than delaying, this would be the time to go for it, because it's also a fairly quicker process, as we will elaborate. So it's better to do it now than later.
Absolutely. And so can you tell us who qualifies for that SBRA?
Right. So to qualify to file under the SBRA, you would, of course, have to have a debt of currently up to 7.5 million. So that will be in place till March 2021, and then most likely it will go back to 2.7, which is what the original threshold that they started with. So they will probably go back to that. So an entity or individual looking to file under this would have to be right now under 7.5 million. And so there's a caveat of sorts here, where you just don't have to have that debt, but you also, as a debtor, have to be able to prove that your pre-filing debt, 50% of that comes from commercial or business activity. So that is definitely something that they require you to prove to qualify. So that's what they've made as like a eligibility factor. And when they were making, when they came up with this definition, they have left out, it's important to note that they've left out any publicly traded corporations or their affiliates, and also any debtors that own single asset real estate. So they've been left out as well, and any affiliates of such have been left out. So those two categories would not qualify even if they had a below 7.5 million.
Got it. Thank you, Shragan. That's helpful.
Sure.
And so if we can move over to our New York office, Delaware, can you tell us some of the major benefits that businesses or individuals receive by filing under the SBRA?
Thank you so much, Jamin. I think this is a very good question and very crucial to the discussion today, because this is a new avenue for small businesses, and not many businesses are aware of the benefits which SBRA offers. So just to shed some light on it, to start off, I would say SBRA is a much more successful, the likelihood of success in SBRA plan is much higher than a typical Chapter 11 bankruptcy. And the reason is, the primary reason is that the debtor maintains control of the operations and the case itself. What it means is that the debtor has the ability to just file the plan. However, in Chapter 11, typical Chapter 11, the creditors and other interested parties can also file the reorganization plan. However, under SBRA, only the debtor can do that. So debtor has a lot of control, not just on the bankruptcy proceedings, but as well as on the control of the business operation itself. The debtor continues to, manage the business themselves. They do not have any interference from the creditors and the court under the subchapter 5. Another important aspect which I would like to highlight over here is that subchapter 5 SBRA provides very less documentation. Like under this chapter, subchapter 5, very less documentation is required in comparison to other bankruptcies. And the reason is that under SBRA, the debtor does not have to file a separate disclosure statement, which is the case in the typical Chapter 11 bankruptcy. Debtor has to file a separate disclosure statement. Under SBRA, you just have to file a reorganization and a payment plan. And this reorganization and payment plan needs to include the business operation, like a brief outline or a history of the debtor's operation, how they were conducting business before filing bankruptcy and how they do plan to conduct it after filing bankruptcy. Then they also need to provide a liquidation analysis and a feasibility analysis, which would provide, the projections of the debtor's ability to perform under the plan and the payments it will be making under the plan. And moving forward under SBRA, to execute this plan, the plan confirmation itself is very easier under SBRA. And the reason is, one, that they have eliminated the absolute priority rule as it is the case in the typical Chapter 11 bankruptcy. It essentially means that the court can confirm a plan even if the creditors or the unsecured creditors object to it. But the condition is that the projections provided under the business plan, under the reorganization plan, will be applied to the plan during the 3 to 5 year period. Then, in addition to that, there is also no necessary voting requirement to approve the plan. This means that the court can confirm a plan without the approval of all the classes of creditors. This is, again, a big benefit in comparison to other bankruptcies. And moving forward, one of the major benefits which is being offered under this SBRA is that only the debtors can change the plan after it is confirmed. This is something very different from other bankruptcies and is very important to note. To explain it, I can probably provide an example. So let's suppose the debtor is in the business of selling airline tickets. And as you know, currently this business is the one which is most affected by COVID. And, there is very less sales. A lot of these kind of businesses are filing for bankruptcy. So let's suppose they do, file for bankruptcy now, and then they do not really know when exactly this period of COVID is going to get over and when is the vaccine going to come out. But let's fast forward 6, 7, 8 months, and suppose that Moderna or Pfizer has provided the vaccine and it's available in the market, and now the ban on the air travel has been lifted. Suddenly, business changes, significantly improves. Now, in that situation, under SBRA, a creditor cannot come and request for the modification for higher payments, but considering that the business has significantly improved. However, the modification to the payment plan can only be done by the debtor himself. If they feel that they want to do it, they can do it. And this is a two-way thing for a debtor. The debtor, let's suppose on the off chance that their business suddenly declines, for whatever reasons. In that instance, they have that ability to modify. They can request for a modification under the plan. So that's a really advantageous position for the debtors under SBRA. And in addition to that, SBRA, as my other colleagues have already mentioned, is much more affordable and much more quicker. So yeah, these I believe are the major benefits which are being offered under SBRA.
Thanks, Delaware. So what are some of the points you mentioned? The affordability. Talk to us about that.
Yeah, for sure. Affordability is, as I just mentioned, is one of the benefits and is really important for the small business owners. That why should they even choose this SBRA over Chapter 11, Chapter 7? So affordability is the main point to note over here. As we have mentioned, there is no creditor committee appointed in SBRA, which essentially means that because there is no creditor committee, the debtor will not have to pay the committee's attorney's fees, which usually amounts to several $1,000s under typical Chapter 11 or Chapter 7 bankruptcy. So that's one. Then there is no U.S. trustee fees. This is in contrast to the typical Chapter 11 case, where quarterly fees are due to the U.S. trustees based upon the debtor's receipts in any given quarter. So these are something which make it more affordable. And in addition to that, as I just mentioned previously, that there is no disclosure statement requirement, which essentially means that because there is no disclosure statement, then there are not going to be any potential contested hearings. And because there are going to be no potential contested hearings, this is also going to reduce the cost and expenses. Lastly, and most importantly, this is also important for us as well as law firm and attorneys. The administrative expenses of this SBRA are quite reasonable and lower, and actually are paid over the life of the bankruptcy proceedings. In comparison to Chapter 11, where the attorney's fees are to be paid before the claims become effective, under SBRA, debtor's attorney post-petition fees can be split over the period of the entire bankruptcy the period of that entire plan. So this puts the debtors in a relatively much more comfortable position, and it becomes really easier for those debtors to be in a position where they can afford it.
Right, and splitting up the attorney's fees, although the court still has to identify and approve the attorney's fees in a Chapter 11 case, it's certainly helpful to the debtor when they can pay it over the entire plan term. It's certainly beneficial for them in that sense. So are these SBRA cases, are they resolved a little bit faster than regular non-subchapter 5 cases?
For sure, yes, they are. This entire process is a little quicker, and the reason for it being quicker is that there are shorter deadlines. For example, when you file under Chapter 11, you get 120 days from the petition of filing to file the plan of reorganization. However, under SBRA, this timeline is even reduced to 90 days. So once again, this is quicker. From 120, now you have to file it within 90 days. That's one. Then there is also a conference deadline, the status conference deadline. So before you file the plan, you have to present in front of the bankruptcy court a conference deadline, which must occur within 60 days of bankruptcy filing. And prior to that, the 14 days prior to that filing, you have to let the court know what exact attempts you have made as a debtor to achieve a plan of reorganization. And in this process, there is another layer of trustee appointment. We'll talk in a little more detail later, but this trustee appointment also really helps both the creditors and the debtors in reaching a consensual plan, which can later be executed. And lastly, and most importantly, because there is no creditors committee, this really speed things up. And this entire SBRA plan usually comes to an end in a much faster manner than other bankruptcies.
Great, yeah, definitely speeds it up in comparison to the non-subchapter 5 cases. Thank you, Dilaver, that was great.
Thank you.
And so we're going back over to California to our Los Angeles office. Min, do you feel that cases filed under the SBRA are more likely to succeed than the other non-subchapter 5 cases?
Yes, absolutely.
Hi everyone, please join us outside for our special lunch. Thank you.
Subchapter 5 Small Business Reorganization Act has an increased success rate. This means that it's more likely to reach plan confirmation. Before the Small Business Reorganization Act, businesses struggling had two options for bankruptcy, either file Chapter 7 or Chapter 11. Chapter 7, the court would appoint a trustee who would manage the company and liquidate everything, and the company would close and everybody would move on. In Chapter 11, the debtor retained control over the daily operation, but the debtor is subject to increased oversight. As we previously explained, they have to maintain the monthly report to the court. Most actions outside the usual course of business needs court approval. Because of those reasons, Chapter 11 is long, costly, complex. A lot of big companies like American Airlines, Pier 1 Imports, J.Crew, Neiman Marcus, they've all filed for Chapter 11 this year. They can't afford the cost and the time. But we have a lot of small businesses in many circumstances. These small businesses, it's too difficult for them to successfully reorganize under the regular Chapter 11. For example, clients who have one restaurant with one bank account, the bank account ran out of money, but there's still a lease for another 3 years. And their bank account is out of money and they are barely affording payroll. They can't afford to hire an attorney to file for bankruptcy. And if it's a corporation, and they have to be represented by an attorney. And then they just close shop and in essence, let the creditor come after them. There's no money in the bank account anyways. So Congress created the Small Business Reorganization Act to help. As we've all previously mentioned, the SBRA is more affordable. And it's more affordable because there's no creditor committee, or the creditor committee is unlikely. In subchapter 5, the committee of creditor will not be appointed unless the bankruptcy court orders otherwise. And since there's no creditor committee, there's less costs associated with it, because in the regular Chapter 11, the debtor would have to pay for the professional advisors of the committee. In subchapter 5, there's no committee, no advisor, so the debtor doesn't have to pay for that. Also, because there's no creditor committee, we don't need the creditor committee to approve the plan. The judge will approve the plan. Creditors can challenge, but most likely the debtor will formulate a plan, submit it, and the court will approve it. Chapter 11 requires the debtor to file disclosure statements, and the SBRA, the disclosure statement isn't required, so that would eliminate another hearing and another cost. There's no U.S. trustee, so the debtor doesn't have to pay the quarterly fee. The administrative expense doesn't have to be paid up front. It's paid throughout the term of the reorganization, so the debtor saves expense on that. Another benefit and another reason why the SBRA is more likely to be successful is that it's quicker. There's a mandatory status conference that has to occur within 60 days from filing bankruptcy, and the debtor has to file a report prior to the status conference, 14 days prior, detailing what attempts the debtor have made to achieve a plan of reorganization. There are shorter deadline for a filing plan in the SBRA context. And then the trustee is appointed. The trustee isn't like a Chapter 7 trustee where they take control of the business, but it's more of a moderator and they work with the debtor and the creditor. So the debtor still maintain control of the operation. And the trustee just moderate and help resolve the case and help move the case forward. SBRA is also more likely to be successful because of the absolute priority rule of Chapter 11 no longer applies. So the shareholders, the equity owners, can still retain ownership even if the plan moving forward doesn't pay all the unsecured claim in full. There are some requirements. The debtor has to show that the plan doesn't discriminate unfairly and it's fair and equitable to all impaired claims. And it's also more successful because the debtor does not need to accept plans from other people. The court can confirm even if their classes of creditors vote to reject the plan. So only the debtor can file the plan. and this prevents lenders, creditors from filing a competing plan, and it avoids the contested hearing, the litigation related to that. And for those reasons, the SBRA is more likely to be successful.
Great, thank you, Min. So Chapter 11 is known in general to allow debtors to keep control over the businesses despite the financial issues. So can you tell us more about how the SBRA kind of fits in there and how it takes it further?
Yes, thank you, Jamin. So Chapter 11, the debtor maintains some control of the business, but the trustee maintain control of the case. For the SBRA, the debtor maintain control of the case and its business operation. This is because the debtor is the only party that can file the reorganization plan. So they're controlling the bankruptcy case. They're the one that decide where they're going with the case, what type of plan they want to impose, how they're going to effectuate the plan. They're also controlling the business because they're running the daily business operation, and the trustee just moderate and make sure everything flows. The equity holder can retain equity interests, and this is different than the regular Chapter 11 because there's no priority rule. This is important to small businesses because as a small business owner, you're continuing to run your business even post-bankruptcy. And lastly, the trustee does not possess or operate the business. So in a Chapter 7, the trustee comes in and they're the one that wind down the business. In this subchapter 5, it's the debtor that's maintaining and operating the business.
Great, thank you, Min. So certainly bankruptcy is generally it's a smart option, but sometimes a last option for businesses and individuals. So can you tell us, Min, please, about some of the other alternatives that businesses or individuals can pursue prior to filing for bankruptcy? Yes,
absolutely. I recommend that the debtor try to do an out-of-court settlement, negotiate with the lenders, with the creditors, with the landlord. It's good to try the step first because when you have these out-of-court settlements, it's private and you dictate and it's faster. When you file for bankruptcy, it's public information and you lose some type of control. I find that it's helpful if you file or draft a petition, a bankruptcy petition, and you can bring that to the landlord and tell the landlord or the creditor, lender, I'm planning to file for bankruptcy. We can't survive. This is my petition unless you want to work out some kind of repayment plan or do something so I don't have to file this. And that works. Another option is talking to your lender about restructuring or financing your mortgage. There are forbearances. This is when your mortgage service or lender allow you to temporarily pay your mortgage at a lower payment or pause payment. Eventually, you'll have to pay it back, but it gives you some breathing room. And then there are other state laws that would help. Specifically in California, there's the assignment for benefit of creditor. An assignment for benefit of creditor is a California state law. It's an alternative to liquidation under Chapter 7. In an assignment, the business transfer all of its assets and liability to another individual or business, and a receiver takes over the company and liquidate the assets in favor of the creditor. Each state is a little bit different, so you can reach out to us to look into your specific state.
Great, thank you, Min. Yeah, agreed that each specific state has their own nuances in terms of restructuring or bankruptcy state laws. So definitely reach out to us and we can kind of guide you accordingly. We have a section of the chat open, so if there are any attendees that have questions, please feel free to post your questions there, and we're happy to answer them. And while that's going on, we'll pose some of the earlier questions. So let's say, for example, there is an entity that has $10 million of liability and only $1 million of assets. And so for the attendees, when you file a bankruptcy petition, there's a form that you have to fill out, or that your attorney will fill out, and essentially that asks you, what your assets are, what your liabilities are, and then debtors and that type of thing. So let's assume for this particular hypothetical that there's a business that has $10 million worth of debt and $1 million of assets. And so if we could go to Esther first, let's assume that Chapter 7 is not an option for this particular scenario. But if it would be, it would just be a straight liquidation. They're pretty much, it's a garage sale. They're selling everything off and then paying off the creditors to, whatever they can potentially receive from the sales. And so, Esther, if you could kind of just run through, just a high level when it comes to Chapter 11, what would that company do?
Sure. Yeah, so first, the company obviously need to decide how much they altogether owed, from their finance background, and also separate their debts to the different creditors. They also need to prepare the different schedules, like the schedule for the debts, and to categorize each claims. For example, it can be secured, unsecured, or there's mortgage, different creditors. So definitely, this is all the things need to be prepared, within 14 days after the filing. But obviously, for the first day, there will be the first day motion, and they need to submit several different forms. But the most important procedure I think I would like to discuss is about how to continue operation on the business during the Chapter 11. So because the Chapter 11 bankruptcy process allows the debtor to stabilize its operations. So as mentioned previously, the debtor in position, they may seek specialized financing in order to utilize the capital to continue operation. So in that case, once they get approval for the financing, they will should send a notice to the different vendors and the creditors, and just to update them of the status of the case, how much financing they've already obtained, and how much they are able to pay for the operation of the normal business course. So in that case, all the vendors will have an idea what would happen. So of course, they also will set up general bar, which is a deadline for all the potential and existing creditor to file their claims against for the debts. So of course, during this period, they can continue operating. They can continue maintaining the executed contract as they like. They will continue working with the vendors to buy things and to have the service and to let it continue. But as I mentioned, if it's entering the new contract like leasing or engage the professionals to provide the specialized service, obviously this kind of service should be get approval from the court. So basically, all the financing capitals can be used for the normal business course. Thank you, Jamin. Yeah.
Thank you, Esther. And so let's do a different scenario now that we talked about a little bit more about the SBRA. So let's say I have a hospitality business, and I have two LLCs. One owns the land, and then one owns the business. And so, Shagun, if you can kind of tell us about that, and keeping in mind that it's under the threshold limit, can you give us some pointers there?
Sure, Raymond. So in the scenario that you pointed out, you say that one LLC, like one entity owns the land and the structure on it, that is the hotel, right? So if we look at the definition of who qualifies for filing, yes, you have below 7.5 million, that's a check. But then if you can prove that, okay, 50% of your pre-petition debt was from commercial activity, that's another check. But with your two entities, it's a yes and no answer, because the one that owns the land will be like owning just the land. So that might qualify for your single asset real estate exception there. So they may not be able to be qualified for this. But the other LLC, which is the company, which owns the hotel, which is running the actual business, they may be able to qualify if they check all the other boxes. But this one may not, because they do have the exception of the single real estate entity there.
Great. Thank you, Shagun. Dilawar or Min, if you have any other points related to that second scenario.
Yep, sorry, Jamin, can you please repeat that?
Yeah, sure. So the second scenario is essentially that we've got two businesses. There are two entities. One LLC owns the land, one LLC owns the business. And let's assume for this is that there's $7 million in debt and $1 million in assets. And it's a hospitality business. And, you know, the vaccine's coming out next month. Travel is going to go up. Business travel is going to go up. I have a flag hotel that's that does really well. It's next to Atlanta Airport, and so because of the reduction in travel, it's a temporary situation. So from your points, is there anything else that the filers should consider?
I think I have already discussed in my part that one thing which will really benefit the filer, the debtor over here in this case, is that the reorganization plan can only be modified by them, even if their business is going to take, going to be producing better results. They would be under no obligation by the creditors to change or modify that plan. So essentially, they are going to be at an advantage in this kind of a scenario under SBA, where despite having a better business, they would be under no obligation to change the plan. So yeah, it's going to be a beneficial situation for debtors under SBRA.
Absolutely. And then Min, what would you recommend in terms of trying to work out something prior to filing for Chapter 11 under Subchapter 5?
I would plan in advance, as if I was going to file, come up with the reorganization plan so that we could talk to the creditor and the lender, and that way they will take you seriously. A lot of times when I talk to creditors and I tell them my client doesn't have money, the response is always the same. Everyone tells us this, no one has money. And it becomes a credibility issue. They don't believe us. But if you can back it up and prepare as if you are going to file, then it's better to negotiate with the creditors.
Absolutely, I agree. So there's a question. What are the various names of fees for filing Subchapter 5 proceedings? So there's the Bankruptcy Code has a fee schedule, a various fee schedule that we're happy to share with you. But there's certain fees that kind of go across the board, and so happy to share that with whomever it is. Our contact information is actually on this next slide, and please reach out to us, and happy to share all of that with you. If there are no other questions, I'd like to just end by saying that the economy was up from July to September, up 33%, and things are looking up. But certainly there are provisions in the law that allow for certain restructuring and discharge, and that's kind of the topic that we covered today for that particular reason. I certainly hope that there's some sort of second round of stimulus packages for the businesses and individuals that need it. But that will come in due time. And so I'd like to thank Esther, Min, Shagun, Delaware, Deepa, Francesca, and Sasha for putting on this webinar series. And as always, thank you all for attending, and I wish you a great day and a great rest of the week.